Intellectual property, or IP, are rights that are granted by the government to encourage innovation and creativity.
The term was originated to come up with a defense of certain types of monopoly privileges, primarily patent and copyright law, which had existed for a few centuries in the West. Intellectual property is not property in the same sense as normal property rights, because normal property rights are designed to protect scarce resources, things in the world that we can have a conflict over. This includes our bodies and other resources in the world, tangible material objects. Property rights arise as a social mechanism to allow us to use these resources cooperatively and peacefully and productively with each other. But intellectual property covers ideas and non-scarce resources, patterns which can be infinitely copied and multiplied.
One of the benefits of having property is the ability to keep other people out. I can let people that I don't want to come to my house know that they can't be there. And patents and copyright provide the same sort of what's known as exclusive rights that private property does, that you can say you can't trespass on my invention and you can't copy my new creative work. So the difficulty when we look at intellectual property is how do we know where the boundaries are? But as far as what are our rights, the idea that we can keep people out, that's exactly like physical property.
Legally, the proper way to understand intellectual property rights is a negative servitude or a negative easement. And if you understand what a negative easement is, it gives the holder of the easement a right to prevent the owner of existing property to use it the way he sees fit. And these are perfectly legitimate if they're granted voluntarily, like in a restrictive covenant in our neighborhood. But in patent and copyright, the government grants these monopoly privileges to holders of these ideal rights, and it allows them to stop other people from using their bodies or their other property as they see fit.
There's a number of philosophical justifications for intellectual property, but one of the clear ones is John Locke's principle. The idea that if you put your effort and mix it with nature, you should get property rights in the resulting object. If you take a tree and turn it into a barrel, the barrel should be yours. And that's the same idea with intellectual property. One of the things intellectual property does is it allows you to get exclusive rights on what you invent, and with those exclusive rights, you can either keep other people from doing it and manufacture the invention yourself, or you can license it to a patent licensing firm. The inventor, who has spent a lot of time and money in the uncertain activity of inventing, can recoup some of those costs and some of those expenses.
So the question is not whether a given policy or law incentivizes innovation. The purpose of law is to protect property rights. We have to recognize that in today's world, even though we have copyright law, piracy is rampant. In today's 2017, artists have to deal with the fact of copyright piracy, and they have to come up with business models to work around that. But then the question is, absent patent and copyright law, what protections would they have? Well, first of all, they have property rights like we all do. They have the right to own their own studio or their own printing press or their own machine shop and make inventions. They have the right to engage in commerce and sell their goods. You can sell tickets at a concert. You can sell a CD if you want to. There's nothing prohibiting you from selling a CD just because you don't have a copyright. It's just that other people could sell a copy of it too, so you have competition.
There are a number of things that are happening right now that are causing uncertainty in the patent system, devaluing patents, and decreasing the public's confidence in the patent system as a whole. The Patent Trial and Appeal Board is getting rid of lots of patents, invalidating lots of patents, and a number of these patents are on really great, innovative technology. So what I would do to reinvigorate the patent system is change the way that bad patents can be invalidated by making it more certain and less harassing for innovators and patent owners.
So the primary reforms I would make would be to patent and copyright, and the primary reform would be to immediately and completely abolish both patent and copyright law. I think we would instantly be way better off in terms of innovation and freedom. Just because something has been in place for 200 years or so doesn't mean it's just. When people copy, they're learning and they're emulating what people do. We have to not be afraid of competition. We have to embrace private property rights, and we have to understand that state-granted rights to protect you from a competitor are the opposite of a free market, and they undercut private property rights.
With patent rights, what we've gotten is a ton of innovation over the last number of centuries great inventions, fantastic inventors that are worthy of being protected, and we're all enjoying the results of this activity. If we don't have this strong patent system that has allowed for this level of innovation going forward, we might get less innovation and a lot less cool toys to play with.